Welcome to our presentation on the elements of the offense, an understanding of what you are investigating. So, the elements of the offense are the conduct, the really core central pieces that establishes culpability. As you know, it's important that elements of the offense are included as part of the investigative plan. We want to use language that is plain, simple, and easy to understand. An investigator cares about the elements of the offense because they are really critical to a successful outcome. While often seen as the venue of attorneys or legal professionals, elements are a part of the core investigative plan. It's important because these are also the way the jury will understand what the law is. If the elements are too long or bulky, they become confusing and add complexity and unnecessary delays to the investigation. So our goal here is to break it down and make it as simple as possible, and by using short, small phrases. So the essential elements are those specific items of a criminal statute that must be proven, each of them beyond a reasonable doubt. Very often, they are included in the indictment from the grand jury and must track that statutory language. As investigators, we need to be thinking about this from the very beginning of the case. Let's take a look at one case. Here, the defendant was charged with a violation, but the circuit court held that it was fatally defective because it failed to include, for example, the false representation, which induced the victims to pay money. Here's another case. This says that it must be not just the statutory language, but also must be accompanied by facts and circumstances that will help the defendant understand what they are being charged with. So, this is where breaking it down is so essential. Because we use these for the investigative planning process, we can also think about them in terms of potential defenses or weaknesses. We want to constantly go back and make sure that these are part of the investigative process and that we're constantly reviewing them. We want to make sure that the evidence is sufficient. And remember, the criminal burden is beyond reasonable doubt. These can also be essential for interviews to help guide that planning process as well. So let's remember that elements are those short summaries of the legal parts that must be proven beyond a reasonable doubt in a criminal case. One best practice is to look at pattern jury instructions. Now, most of the federal circuits and many states publish these, and these are essentially what are used by the attorneys and the judges to guide the jury in the instructions. But you don't need pattern jury instructions. You just need some time and some expertise. So we're going to break down an example. This is the Indiana state burglary statute. As you can see on the left, it's pretty extensive. So we want to move from this to something more simple. So for example, here we have a defendant who broke in and entered a building or structure that was owned by another with the intent to commit a felony or theft. So when we look at these, we want to collect evidence that goes to each one of these elements. So for example, if it is owned by another, we need to get public records that show who the owner actually is. Now, this is also interesting because it gives a breakdown of different levels. So for example, the lowest level is level 5. That's just simply breaking and entering with the intent to commit a felony or theft. Now, level 4 is is enhanced if it's a dwelling or somebody's personal residence. It becomes a level 3 if there's bodily injury. It becomes a level 2 if the defendant is armed with a deadly weapon or there's serious bodily injury. And of course, a level 1, the highest, is a dwelling and resulting in serious bodily injury. So again, you see from a whole how this all comes together. So if you're investigating this, now you're really paying attention to each of those 5 specific elements and then all the different parts and levels that could enhance it. So this is the mail fraud statute, 18 U.S.C. 1341, sometimes called the workhorse of the federal statutes. As you can see on the left, it's pretty extensive. We are breaking it down. A scheme to defraud, the mailing of a document or letter for the purpose of executing the scheme. It's that simple, right? Now, definitions are so important. So, for example, in this case, we see a criminal code from Indiana that is conversion or misappropriation of title insurance escrow funds. Well, I am no expert, so I don't know what a title insurance escrow account is. But the law helps me because it gives me a definition. So, in that statute, it says the title insurance escrow account is any account which written instruments, money, or items are deposited and held in either escrow or trust for disbursement to a party in connection with a residential real estate transaction. Again, now we're really starting to be able to break down those definitions, understand what they mean, and be able to do interviews and plan our investigation accordingly. So we'll go through another example here. This is tax evasion. As you can see here, pretty simple. It's an attempt to evade or defeat a tax or payment. There's additional tax due and owing, and it's willful. So let's go through those definitions. An attempt is making some affirmative action with a tax evasion motive. The evasion is a false or fraudulent action, for example, that conceal funds, assets, or information. And willfulness is the voluntary, intentional violation of a known duty. Again, using all of these, we are planning the investigation. We are looking for what that person did or didn't do, different transactions, different documents, digital evidence, interview, testimonial evidence, all of these that either support or refute those 3 elements and their definitions. So we'll do one final example. This is bank fraud. So bank fraud is the defendant knowingly executed a scheme to defraud a named financial institution by the means of a false or fraudulent pretense, representation, or promise. Civil cases are just as similar. So, for example, this is common law fraud, a representation about a material fact which is false, done intentionally or recklessly, believed and acted upon by the victim to the loss of the victim. Again, easy to follow. Definitions still matter. So, from a civil perspective, intent to defraud is acting knowingly with the intention or purpose to deceive or cheat. And again, these are all things the jury is going to consider. Thinking about gain or benefit directly or indirectly, the expense of the victim, whether it's an entity or a person, and a desire or purpose to cause a loss. So again, all these definitions come into play, whether you're talking civil or criminal. So as we wrap this up, let's think about this is all about breaking it down into single words, short phrases, do one element per line. It should be simple and easy to follow and avoid anything that's confusing or muddying the waters, extraneous items. Again, break it down, break it down, break it down. So I hope this was a helpful presentation. Understanding the elements of the crime is critical. Being familiar with the case law, keeping up with it, reviewing definitions of the key words, and keeping a list of these and keeping them close by, especially as you're doing interviews and, and investigative planning. And finally, keep those all together. I hope this was helpful. Feel free to leave any thoughts or comments, and good luck.